This meeting we will commence an open session. Just advise members all mobile phones must be set to airplane mode and on silent or turned off. If not sufficient to put it's not sufficient just to put mobiles in silent mode, as they continue to interfere with assembly recordings. And just to be aware, this session has been recorded in video and audio and can be accessed live via online streaming either on the Assembly website or Democracy Live. And just remember, anybody in the public galleries, if you want to use your mobile devices through a Wi-Fi connection, all devices should be muted and password details are available. Members, agenda item 1 is apologies. I have an apology from Michelle Gildernew. Any other apologies? Declan Kearney.
Could be here.
Could be here. Okay. No other apologies. Members, agenda item 2 then is minutes of the meeting on the 29th of June 2016. Can I just refer members to the draft minutes of the meeting on the 29th of June 2016, is it pages 5 and 7 of the pack? Members, are you content that's a true record of that meeting?
Great.
Great. If so, I'll sign as being accurate. Members, matters arising, just refer you to pages 9 to 13 of the pack, is the invitation to the PAC symposium. Just to advise members that this was discussed at our planning meeting, and it was agreed that those who are interested in attending would advise the clerk by today. Members, I know some round the table have already indicated whether they're going or not. Trevor, are you?
I just don't know anything about it. I mean, what is it? It says a 2-day and a 4-day.
Well, it'll be the 2-day we'll be going to, if you're interested in going to, which is the workings of PAC at an introductory level.
PAC conference.
Yeah. Yeah. Okay. I think everybody else has indicated. Okay, moving on then, refer members to the memo at pages 14 to 16, which provides a summary of the discussion which took place at the strategic planning meeting on the 7th of September. I just invite Lucia to speak to that.
Okay. Thank you, Chair. Well, the first bit of the afternoon was spent looking at reflections so far and what members' experiences had been. So there was some discussion around the preparation for an evidence session, just to streamline things. The professional development then also looked at what additional training or support members would be interested in, including the symposium. So it was agreed then that members would, go and think about that and come back on whether they were intending to go to that symposium, which you've just covered. There was a reminder about the protocol which had been presented to members at the very first meeting of PAC, which looks at issues around attendance and just how the committee is going to work together. And it was agreed that that would be brought forward again today, just to remind members about that protocol. There was then discussion, quite a lengthy discussion, around what a PAC strategic plan might look at, and looking back at an example that had been used by the previous PAC, and some of the key things that members agreed on was that there was a need for a change in processes and cultures within departments in a way that would enhance the capacity of the committee and the audit office. And so it was looking very much at how PAC could be more effective and possible actions coming out of that included meeting with the head of the civil service, the Northern Ireland Audit Office and the Finance Minister, just to take forward some of those strategic areas. There was a discussion around best practice, what exists elsewhere and what PAC could learn by looking at other PACs, not just within these isles but in other parts of Europe and beyond. So it was agreed that some research would be useful in that. There's a discussion around enhancing the profile of PAC, and that was something again to go away and look at. Visits outside of PAC, outside Parliament buildings was also discussed, and so there was some sort of ideas on that and how that could be taken forward. The take note debate was discussed as well, and whether it was the best mechanism for promoting the work of PAC. And I think from all of that, there was quite a lot, as you can see, there's quite a lot came out of that. So it was agreed that a more in-depth paper could be brought to the committee in October to look at in terms of how you would move some of this work forward. So I suppose in summary, the actions that came out was one, who and if people were going to go to the symposium, to reinforce the protocols, to write to the head of the civil service, the finance minister and the CNAG to arrange meetings to discuss strategic issues, commission research on examples of good practice of other PACs, look at how to enhance the profile of PAC, review the take note debate, and to come back with a fuller paper with proposals on the way forward for the 12th of October.
Okay, members, that's I think a detailed response of our plan on the way day, and I think there's a lot of actions there that we agreed to take forward, and ask the clerk to work out the detail of and come back with a paper for further discussion on the 12th of October. Carla?
Mr. Chairman, I actually thought the clerk was to have it all done by today. No, I'm only joking. I just want to actually commend you and the officers. I thought it was a very, very useful day, and certainly I look forward to hearing the response back on them in due course.
Yeah, thanks, Carla. Yeah. Okay, members, content? We'll give you the 12th of October then, if I'm not. Okay, members, just also that was discussed at our away day was the protocols that we agreed on the first day about what we expect as a committee, and a copy of those has been provided in hard copy. So just if you could take note of those again. Okay, members, moving on then, agenda item 4 is correspondence. Can I just advise members there's 2 items of correspondence to consider. The first piece of correspondence is from Mr. Brendan McFerrin regarding Invest NI. That's at pages 18 to 65 of your packs. Just as an outline, Mr. McFerrin was the former Chief Executive of CAM Benchmarking, which received funding via LEDU, and following an investigation by KPMG, Mr. McFerrin was suspended and the company was wound up in March 2009. Could I just ask our CNAG for comments? Kieran, you're very welcome, by the way.
Thank you, Chair. This is a very old case. We thought it was closed down 5 or 6 years ago. Mr. McFerrin was the former Chief Executive of a company called CAM Benchmarking, which received funding from LEDU. LEDU's long gone. So this really does go way back into the mists of time. My predecessor actually received a notification into suspected fraud at CAM Benchmarking way back in 2005, and after that Mr. McFerrin was suspended, and the department at the time commissioned KPMG to carry out a forensic investigation, and KPMG produced 2 forensic reports in 2006 and 2007, and there were some irregularities, expenses being claimed from both the company and LEDU, payments of company directors' fees to the principal director, that was over and above his salary, and there was problems with credit card usage. The company was wound up in 2009. Mr. McFerrin took a claim of unfair dismissal and disability discrimination to an industrial tribunal in November 2009, and the tribunal established that all claims were not founded, so none of it stood up. So I see this matter as closed years ago.
Okay. Members, any comments? Either on the correspondence, on the CNAG's comments, Trevor?
Are we on the record?
Yeah.
So it's just
took time to read through it. Is it similar to, or is it the same correspondence that we had in June, May or June? It looks very familiar to me. It was one of the first things I looked at. Is it the first time I would have had sight of that one? Yeah. There's correspondence we received, I don't think.
It was not the same,
No.
the same case.
Okay, that's fine.
Okay, members, any other comments?
Chair, just I suppose the usual thing is, have we got assurances that this will not recur? Obviously, it's Invest NI we're talking about. Or?
There was huge issues back with the former LEDU with what we call third-party organisations, of which CAM benchmarking was only one.
Right.
There were others actually with big problems as well, such as Emerging Business Trust. Some of the casework actually went at the time to the Westminster Public Accounts Committee. And to be fair to the department, the controls were tightened up following the creation of Invest NI.
So the risk is relatively low of repetition?
These are problems in the distant past. The real distant past, yeah.
Okay.
Thanks, Chair.
Okay, thanks, Gordon. Members, nobody else. Members contend then we write to Mr McFerrin to advise him of the outcome.
Great.
Yeah, we'll note it, yeah. Okay. Members, the second piece of correspondence is from Mr Austin Johnson regarding EOS Works Limited, Carrickfergus, is at page 66 to 69. Mr Johnson has been attending this organisation which helps employ people back to employment, and he claims that the organisation needs to be audited, and in his opinion it is poorly run. Kieran, have you...
This seems quite an individual personal case, so it's probably best dealt with through other channels rather than through this committee. That would be my thought on it.
Members are content to pass it to Committee of the Economy, which I think would be the direct avenue to deal with this, because they have the ability. I think ETI does inspect EOS and other providers. Members content?
Great.
Okay, members, we're moving on then to agenda item 5, Ministerial Direction. Can I just refer members to the memo from the Clerk and associated papers at page 72 to 77 in respect of a Ministerial Direction in regard to United Airlines provision for financial assistance. Just advise members a Ministerial Direction was sought when an accounting officer requires ministerial cover for a spending decision that is outside the delegated limits. Can I refer to correspondence from the CNAG to myself at pages 76 and 77, which advises the committee that the Department for the Economy Permanent Secretary wrote to the CNAG on the 12th of August to advise that he sought a ministerial direction for grant assistance for up to $4 million to preserve the Belfast-New York route. United Airlines had indicated that without this financial assistance, it would have to have withdrawn from the route due to substantiated loss. And just to advise members, the Audit Office has brought this issue to the attention of the committee and will keep this matter under review as the audit of the 2016-17 financial statement progresses. Kieran, would you like to comment or maybe expand on that?
Yeah, thank you, Chair. Just first of all, in the process, where there is a ministerial direction, an accounting officer is required to inform me, and I am in turn required to inform this committee. So that's the normal protocol. How many of these do we get? Usually a couple every year. Mostly they're where maybe accounting officers' concerns about a value for money judgment on a project, and where the minister said maybe there are wider reasons for going a different direction. In this particular case, there's a couple of things I would like to point out to you. First of all, it's how the support to United is worked out. And you'll see in my letter, the background paragraph, the decision was based on losses sustained due to lack of business class customers, but also the opportunity for the aircraft to be used on a more profitable route. So it's not just to cover losses, it's actually to cover, what the airline could make by using the plane somewhere else. So that's an important point I just wanted to flag up. Also, we go to the second page of my letter, you'll see the Permanent Secretary was unable to recommend the provision of assistance on irregularity grounds. So it's not just value for money, it's irregularity, as it had not secured the normal financial approvals, and it was unlikely it would be approved in any conventional context. I think this is the bit I want to emphasise, especially given United's rejection of any monitoring of the need for a grant. That is most unusual, so I think I should draw that to your attention. What does that mean in practice? I don't know, if you had a hypothetical situation, say if our economy starts to really lift and the line does much better than anybody anticipated, is there still a subsidy to be paid? So there are question marks around this. I will keep it under review, and as time goes on, I'll be required to audit the subsequent expenditure in future accounts. So I will keep it under review.
Okay, Trevor. Yeah, if I read this right, plus what you just said, Kieran, we're making up the losses, the anticipated losses for this route for 3 years, plus we're going to pay them what they expect they would have made for 3 years had they transferred the particular airplane to a different route.
I think that's
and
correct.
There's no monitoring, so as you say, if they do better than anticipated, there's no clawback. I think this is absolutely outrageous, frankly. I know we're keen to promote air connections from Northern Ireland, from all of our airports. I've just listened to comments about Londonderry Airport today, or City of Derry. But this is madness. This is just a bribe. This is take it or leave it. If you don't give us this money, we're going to leave the route, and we give them the money without proper scrutiny. That's what it boils down to. This is terrible.
It's fair to say a lot of the risks are pointed up in the correspondence, both to the Minister and from the Minister to the First and Deputy First Minister. So I think there's all of that's acknowledged. There's
no risk over the 3-year period that we're talking about, because they'll be laughing all the way to the bank.
Well, there's also what happens after 3 years.
I'll try to be so cynical, but after that they'll come back for more. That's just crazy stuff.
Declan?
Thanks, Robin. To what extent, Kieran, would the refusal to accept monitoring conditions have weighed in the consideration of the EFM, or FMDEFM, the Executive Office? It is for me a very irregular scenario to award the funding, but award the funding where the recipient is refusing what I would have considered to be just sensible, transparent monitoring conditions.
It's most unusual. That's why this is almost a double-barreled direction. It's a direction in both the value for money count, the normal one, but also the regularity consideration. It's actually the first one of an irregularity point of view that I've come across since I've come into the job. So it's most unusual.
And
All right.
sorry, were you going to continue?
Yeah.
So have you put a question to the Executive Office, or was an explanation forthcoming, or was there an explanation that satisfied you that they had rationalised why the funding would be awarded in those exceptional circumstances?
At this point, I haven't got into those sort of questions and deliberations. At this point, I was just, I've had a brief meeting with the Permanent Secretary at this stage. At this stage, it was just I'm a conduit to bring this to the committee.
So this is with a view to further action, as opposed to this just being reported as a done deal?
Yeah, I'd certainly have to think, what more do I need to do in this? Yeah.
Yep. Kieran, can I just ask, United have the ability to walk away from this agreement at any time?
Well, there's one other caveat I hadn't mentioned. All of this is subject to EU approval on state aid, so that I can't judge what way that will go. So there is a caveat to it.
Do we know when that reports or when that
I
completes?
don't have the detail on that. So there is that caveat as to whether all this will work through. So we can't judge that one way or the other.
Okay, thank you.
Chair, are the rules on state aid not clear enough that you should be able to know? I mean, it doesn't, in terms of state aid, it doesn't seem like a lot of money. I mean, is it above the threshold? Or?
The purpose of the rules on state aid is to prevent anti-competitive behaviour. Now, could argue there's no other direct competitor in Northern Ireland, so that might be an argument that this is okay.
Yeah, but since we're all at the moment good Europeans, could Dublin not complain?
Maybe, yeah.
But we're not there yet, I think. So.
We're not there. It's a live
So
issue.
Kieran,
Yeah.
as from your continual monitoring of the situation, what's that look like as a time frame?
Well, I'll have to consider whether this is any import when I look at next year's accounts. That'll be the 16-17 accounts.
Okay.
I think the first instalment of money has just been paid out recently.
Right, Robbie?
Kieran, with regard to setting the president, it seems, given the news from the City Dairy Airport and the flight to London and the threat of losing that flight, okay, so it certainly seems to be irregular, but also running the risk of setting a president. Is there any precedent before this event? Is there anything similar? And
No direct precedent, but there was also ministerial directions on the City of Derry Airport back a number of years ago, but that was support not to an airline but to the airport itself. That was a separate direction.
Okay. Second.
Is it within your authority to retrospectively seek an explanation from the Executive Office as to why the decision was made in light of the conditions?
No, I can ask questions, yes, I can do, yeah. Mm-hmm.
So rather...
But it's not it's of the...
Economy.
I can certainly ask questions of the accounting officer, but beyond that then it's in the political realm. So the process, well, the accounting officer would state his position. The minister then would issue direction. In this case, because it was over the summer, the direction was approved by the First Minister and the Deputy First Minister under emergency procedure. The alternative procedure is the full executive would sanction it. So that's in the political realm, and my realm is with the accounting officer.
Okay.
Is it within our remit, your remit, to write to DFM and ask them for an explanation?
I suppose it is. If that's the committee's will, it's, yeah,
I don't know if
certainly
the
right.
committee's will or not, but I would suggest it.
Okay. Seconded, Daigle?
Yes.
Members content to be right to left the MDFM for that authority? Okay, and you'll keep us fully abreast of the financial implications in this?
Yeah, or further development.
Robin, if I may,
Just come back, the Controller in General talked about something that happened in relation to the other airport, but it was for the airport's purposes. But in reading this correspondence, was the airport in this not actually part of the lobby to actually maintain United? Obviously, I presume
Yes.
that it's to do with the viability or otherwise of, or what a negative effect it could have on the airport if they were to pull out.
Yes, absolutely. In this case, some of the support is coming from the airport itself rather than I omitted to mention that in the submission. Yep, that's right.
Okay, Daigle?
But it's just to fine-tune the nature of the correspondence. It's to establish the rationale, political rationale applied to making the decision under these circumstances, so that we have some transparency around the process that's been applied, particularly given that this took place during the summer.
Yep, that's fine. Members content. You know, the time frame was, June, I think, was the announcement, and August was the, or June was the announcement that United may pull out, and August was the date it was agreed, so it was quite a quick timeline for the executive to follow through. Okay, members, content?
Great.
Members, agenda item 6 then, pages 79 to 81 of your packs, inquiry into the Department of Education and the sustainability of schools. It's further clarification on the memorandum of reply. If the members recall, we sought further information on recommendations 4 and 8, and the Department of Education has come back with the replies. Recommendation 4 was basically in regards to the difference between primary schools and post-primaries. They've come back there with a selection of dates, and recommendation 8 provides a list of the stakeholders that we asked for and the levels of activity. Kieran, have you anything you want to
Nothing I wish to
comment
add to that. It's fairly self-explanatory.
Okay, members content? Any questions? Okay, members, if there's no other questions, just to content to await the further update in the usual 12-month time period. Okay. Members, agenda item 7 is the inquiry into the governance of land and property in the Northern Ireland Housing Executive, and again clarification on memorandum of reply is pages 83 to 84 of the pack, and again that we sought clarification as to who actually were the NIHE sponsor team and who made those up. Now they're listed there as, I suppose, staff and grades rather than individual names. Kieran, have you anything on that as a sponsor?
Not really, other than to say it's quite a well-resourced sponsorship team.
Yeah. Okay, members.
Would it not be useful to get the names?
I suppose at what time period, Trevor, could be? You know, there's a grade 7, 2 deputies, 3 staff officers, an executive office 1, 2, and the administrative office. Do you want the time frame of the?
Well, I mean, if we're talking about the sponsor team during that period.
Well, no, not sure if this is what they're doing going forward rather than looking back. Most of those are junior, like a lot of these people are junior civil servants that wouldn't normally be named.
Yeah.
Well,
the first one is a grade 7.
And the deputy principal should be okay to name.
We can ask for the names.
I'd be happy enough for those.
For the top 3 members. Can we ask for those?
Yep.
Right. Okay. And members, then, just to continue to wait, we have an update scheduled in 6 months' time anyway on that one. So. Okay, members, moving on then, agenda item 8 is our inquiry into managing legal aid. Refer members to correspondence received as follows. We have follow-up correspondence from the accounting officer in regards to the Department of Justice evidence session on the 29th of June, and that's at pages 86 to 92. And just to advise members that following the evidence session with the DOJ on the 29th of June, there were a number of issues which members requested further information on. Sean, you're very welcome to the table. Kieran or Sean, have you comments at this stage?
Just general point. The information is useful and can be used to help put your report together. I think the first point really around statement of means form and eligible payments. The response to that really underlines the importance of statutory registration scheme. You'll see on that, at the bottom of the first page, 82 cases were financially ineligible. There's no way of actually doing anything about that in any constructive way, because that got through solicitors. And if you had a statutory registration scheme, you have a mechanism for dealing with irregularities such as that. So that's one of the main points, I think, coming out.
The key point, I think, is that there's no formal compliance regime at present. It's to be introduced as part of the new registration scheme, so it stresses the importance of moving that process forward.
One of the other points you asked about was a breakdown of expert witness costs, but we weren't able to do that, so in a sense the response provides no new information. Again, that underlines one of the themes of the session, just the really poor quality of information, and that again can be emphasised in your report.
Okay. Just a question, I suppose may not have the answer yourselves. The agency received 1,471 files, 1,299. There was information supplied, and according to the DOJ, the difference is explained by the fact that no request for information was either issued or the applicant had died. Why would that case still be open if the applicant was deceased?
I have no take on that.
A good question. Unfortunately, the information we have is limited to whatever their responses are. We can follow that up as part of the report process.
Trevor?
If they looked at 20% on their rolling review, and they found that number of cases which didn't actually qualify for legal aid even though they appeared to have received it, and there were 40 solicitors firms involved, it'd be reasonable to assume that there would be 200 cases if they looked at them all, where a solicitor's firm had wrongly recommended legal aid.
I think that's a very interesting point. Any time you do a sample of work, then you readjust your sample depending on the outcome. Yeah. You're finding a lot of mistakes, then you should dig deeper. Yeah. So it's a valid issue.
Point being, I think I raised at the time that there didn't appear to be any mechanism to investigate the solicitors who may have known perfectly well that they were giving or recommending legal aid to people who didn't qualify for it, or at least weren't doing the proper investigation to find out if they did qualify.
That's the whole point of the statutory registrations, and that's why it's needed to give the tools to actually do that.
What's a mechanism in place?
What's a mechanism in place? So you don't, in a sense, there's no direct contractual relationship between legal services and individual solicitors. So there's a gap there.
Well, statutory registration fill the gap. I mean, will it provide a situation where if a solicitor is suspected of being a bit too liberal with legal aid funds, that they can be investigated, and if so, by who? And I keep going back to Law Society. They don't appear to have any role to play in this.
Well, it should be by the department. The Law Society, incidentally, used to have a role because back in the day they administered legal aid. It is, all I can say is this, the statutory registration, depending on how well it's done, has the potential to do all of that. I suppose the big issue then is just the long-standing delay in getting it on to
putting the mechanisms in place.
So that they're not even at the starting post on it.
So as we stand at the moment and for the foreseeable future, same thing will keep happening.
Until that the first thing that needs done is the statutory registration, and then step 2 is to make sure the detail of that is
and underpin it with improvements in the department's own management information systems. You know, to make sure that they can monitor things adequately.
Well, sorry, Chair, just for the record, is there any indication of timescale?
Can't remember from the session, but
2018 was the one they were in front of us and gave the evidence. They actually said 2018. But Jerry, that's the sort of things we can put into recommendations.
But that's exactly the sort of
report
stuff you can get into in the report.
Okay.
Trevor?
Just following on from the point Trevor makes about the solicitors who got paid for that, is there any way of finding out actually they got paid twice?
You're even more suspicious than me.
Well, given that there's no mechanism to know if they fraudulently made the claim, there's also, I presume, then no mechanism to know whether actually the individual paid also.
Right. I'm just thinking off the top of my head. We have a mechanism in the National Fraud Initiative to pick up duplicate payments, but I'll need to go back and check whether this is an area that's covered in it or not. But there's a potential there to pick up duplicate payments.
The place I used to work, the environment I used to work in, where people get paid claims. In the motor trade, dealers were known to have claimed the payment for warranty items and then charge the customer as well. It was a double whammy. If in this case that they know that there's no mechanism
To catch them.
catch them, then there's nothing to suggest that the same practice wouldn't happen in that field as well.
I'll come back to you on that. It's an interesting area of inquiry.
And they've been doing it on a sample basis for a number of years, and you would expect if there may have been some hit through that process of some form of duplicate payment, but it's not guaranteed that they'll actually identify anything. It's on a sample basis.
Okay, Gordon?
Thanks, Chair. I think we had a very useful session in relation to the management or the mismanagement of legal aid. I think what we would like to see coming out of this is a report, a robust report that's going to bring about change. And there seems to be a great reluctance and an unwillingness to implement change. We think we've seen clear evidence of that.
Yeah.
And to me, there's a lack of commitment right from the top down. And I think we all appreciate it's going to be difficult to implement that change. The people you're working with, they're not used to being challenged, and they're not used to given direction, I think. And they're like cats, they're difficult to herd. But I think, we appreciate the work you're doing. There seems to be, as you've said here, there's no formal compliance regime in place at this time. I think that's a major weakness, and non-compliance needs to be addressed, and I think we look forward to a robust report. And we as elected representatives must ensure that these people don't wriggle out of it, and that there is no wriggle room. And we use the offices that we have right through the Minister to make sure that change is brought about and that it is implemented by those that are expected to do it. Thanks, Chair.
Thank you, Gordon. Karen, do you want to, or Sean, do you want to content enough with that?
We'll probably come back to that later.
Okay.
In the session.
Alex?
Yeah, in figures there, the 15% that were financially ineligible and they had their certificates discharged, was there an attempt to get any monies back of them?
Again, the information we're provided is limited to whatever's in there. I would
We don't
presume we don't know. Again, we can look into that and establish that and consider in the.
Is there any way we can get the names of the 40 firms?
Yep. We could write and ask.
That's good, yeah.
We could write and ask, yeah.
Chair, sorry, my suspicion, that's said openly, would be it's not actually 40 firms. It's several firms having their names mentioned more than once.
Okay. Robbie?
As a committee, should we be satisfied with the response from the taxing master? That
Going to move on to that, Robbie, now.
Right. All right, okay.
Yes. Okay, members, anything else on that section? Members content that correspondence makes part up of the report? Members content? Okay, moving, I suppose, directly onto the point that Robbie has raised, is the correspondence form actually for the Lord Chief Justice Office regarding the request for the taxing master to appear before the committee. It's on page 93. I just will advise members following the evidence session on the 29th of June, it was agreed to invite the taxing master to attend a committee meeting on the 21st of September to give evidence to the committee. In his response, the Lord Chief Justice's Office states that as the taxing master is a member of the judiciary, it is not appropriate for the taxing master to attend the committee meeting on the 21st of September to give oral evidence, as she is independent and impartial. However, they advise that they are happy to answer any specific questions the committee may have. Robbie,
yep.
You want to?
Yes. As a committee, should we be satisfied that is the response, or I think in the discussions that we had at the time, and certainly most of us would have felt that it would have been a useful person to have here.
My personal view is, there shouldn't be really an issue here, but the judiciary is very precious about its independence. So it's the independence thing. They have said we're prepared to answer questions. So I think you're certainly free to express your concerns, Matt, and you can do that in your report.
I suppose my response to her initial thought is that, for the £19 million of public money that she's responsible for, at least as a matter of courtesy, she could have came and answered, even though we have no powers to compel her to attend because she is a member or an employee of the Crown. There is an offer to write with questions, and I think that's the avenue we could take up, because I think we have enough to ask her about. But I think the independence thing, she's dancing in the head of a pin a bit with not attending. But Trevor?
I would think more of the situation if the Lord Chief Justice had said that the taxing master could appear, but would have to, on the day, decide which questions to answer and which not to answer. I mean, she could appear before us, and if she had to say it on occasion, sorry, it's not appropriate for me to comment on that, that's fair enough. I mean, I noticed that who was it, Judge Marlin seemed happy enough to come and talk to us, member of the judiciary.
Okay, Trevor?
Of course, there's an entirely different way to look at this.
I know.
Judges sometimes like to enter the political sphere, not politicians.
Yeah.
I think we should extend the invitation to actually get them to formally refuse. Because, I mean, sometimes they actually play politicians' jobs too. As do the police.
But we have invited, and she has, and they now have
Was that a formal
formally
proposal?
refused, yeah. And I suppose under the ability to call witnesses, we can't exercise it in relation to either a minister of a Crown or a person who is or has been in Crown employment, which covers the taxing master. So we don't have the powers to call. But they have offered the opportunity to write and ask them more specific questions.
So, what is the formal mechanism of accountability then in relation to the taxing master?
She is accountable to the Lord Chief Justice, who claims to be, or is, independent and impartial.
That's your defence.
Who's exempt from being called again, did you say?
Anyone who has been a minister of the Crown or a person who is or has been in Crown employment.
Sorry, what's a minister of the Crown?
Minister.
Simon Hallam.
Yeah, that's what I'm curious.
Marlene Foster.
So they can't be called out of that?
No, can't be compelled. That's under Section 44.1 of the Northern Ireland Act 1998.
They look at that.
That's incredible.
Right.
But
Well, it depends whether a minister of Crown is one of our ministers or a Westminster minister.
That's what I'm wondering, because
Well, we'll seek clarity.
other ministers were called to other committees.
Yeah. It's maybe an NIO minister. We'll seek clarification. Remember, anyway, look, we're divulging from the taxing master.
Which is slightly our term, but I think it's something that maybe we should be looking at as well.
We'll seek clarification on it. In regards to the taxing master, I would have a selection of questions that I'd like to put to her in writing. If members are content, if we circulate them, if there's anything you want to add, and add it, and then we'll see. Robbie?
I think that's very important, and I think the wording of the questions and the way they're put would need to be examined, because it changes the environment with which within they can be answered. It would have been certainly more preferable for to have the tax master here, but
Yeah.
requires a bit of.
Okay, members content with that approach, we'll circulate a few questions. If you could get back as quick as you can, then we can get them away. Declan?
Perhaps, Rob, to preface the questions with, in correspondence to the taxing master, our expressed regret at the fact that she has chosen to decline the invitation, and for that to be CC'd to the Lord Chief Justice at the same time.
And the Justice Minister?
If that doesn't appear to be impudent.
Yeah.
But I do think you're subtly and diplomatically making a broader
Yeah.
point in the interest of wider public scrutiny and transparency. Really, whether you have something to hide or not,
Yeah.
if you're asked to account publicly, it's much better to do your best to facilitate that.
Okay, no, but I think our disappointment has been made clear enough today, and of course in our final report, depending on the answers, we can stress that point. Members, anything else in regards to that? Okay, members, moving on then, agenda item 9. Is our inquiry into non-domestic renewable heat incentive, the RHI scheme, and this will be an introduction to the briefing session. Just welcome Kieran, Gary's been at the table, Tomas, Brian to the table. Just Kieran and Tomas will give us a verbal presentation of the report to date. Members then will move into closed session for more detailed scrutiny of that. So, Kieran, over to yourself.
I'll just pass straight to Tomas, who led on this particular scheme.
Okay, if I could take you through the background to this. Basically, the Assembly has set a target for 10% of Northern Ireland's energy consumption to come from renewables by 2020. And as part of this, DETI set up the non-domestic renewable heat incentive scheme in November 2012, which was based on a similar scheme in Great Britain. There was also a domestic scheme, but there's no significant issues arising in it. The scheme was set up to encourage a move from what was mainly oil in Northern Ireland to renewable heating sources, which in most cases in Northern Ireland meant burning wood pellets in a biomass boiler. The scheme paid applicants a subsidy for every kilowatt of heat energy produced from renewable sources over a period of 20 years after installation. There was no capital payment up front, it was all a subsidy for every unit generated afterwards. The scheme is administered on behalf of the Department by Ofgem, who received claims from applicants and then paid them on behalf of the Department. The claims are based on the amount of heat recorded on meters attached to the various applicants' equipment. In the first 2.5 years of the scheme, there was a relatively low take-up of the scheme, and actually the Department was having problems trying to generate demand. However, in early 2015, the number of applications started to rise significantly, and this started to put the affordability of the scheme in some doubt. But the Department was unable to respond because of its legislation. It was unable to respond quickly and to manage demand by reducing subsidy rates, and as a result, the subsidy rates under the scheme weren't changed until mid-November 2015. And by that stage, there had been a huge surge in demand for the scheme, particularly in October and November 2015, but just in the 7 weeks before the scheme closed, when as many applications were received over 7 weeks as have been received in the previous 34 months. This surge in demand that had happened just before the scheme closed has massively increased the cost of the scheme to around 1.15 billion, which will have to be met over the next 20 years. Also, the Department had always acted on the expectation that all of the costs of the scheme would be met by funding direct from Treasury. In fact, the surge in demand means that all of it won't be met by Treasury, and around £350 million will have to be met from the Northern Ireland Block Grant over the next 20 years. So there are a number of key issues we've identified in the report. I'll just take you through each of those very briefly. One was the failure to obtain DFP approval. The scheme had DFP approval up until March 2015, and it was supposed to go back before it expired to get new approval. But the Department didn't identify this, didn't realise that it was going to run out, and only realised it in May 2015 when they started to prepare the papers then to get the scheme approved again. This is important because if the Department had realised that DFP approval was about to expire, then that might have been the catalyst which would have got them to review the whole scheme and address the numerous weaknesses within the scheme. But as it was, the approval for an amended scheme with reduced subsidy rates wasn't obtained until the end of October 2015, and by that stage they'd incurred nearly £12 million over the 7-month period from April, and that was irregular expenditure in the account. The second point is the structural weaknesses in the scheme. One of the key controls in the GB scheme was that they had two rates. They had the first main higher rate, which was payable for the first 15% of hours in the year. That's the first 1,314 hours of a year. The remaining part of a year was paid at a much lower rate. In Northern Ireland, up until November 2015, there was only one rate payable, a higher rate. As the rate was higher, the rate being paid in Northern Ireland is 6.4p, and as that's higher than the cost of actually putting wood into the boiler, which was 4 pence, there's a clear incentive to use the boiler as much as possible to continue to generate heat, even if that heat hasn't been used. So there's an incentive to use it 24/7, basically. The third point was the inability to respond to changes in demand. In April 2013, in Great Britain, they introduced a system called digression, which routinely reviewed the subsidy rate at each quarter based on the amount of demand that had been received, that they were seeing at that quarter, and to revise the rate that being paid at a month's notice. As a result of that system that they had in GB, the rate of tariff fell by 50% between 2012 and 2016. In Northern Ireland, the rate stayed the same over the same period. It didn't reduce. And again, because Derry didn't introduce that digression system, didn't have that legislation in place, it meant that whenever the huge increase in demand did come, it could not respond quickly, and it took a long time to respond. And that's part of the reason for the huge spike in applications and the effect on affordability. Fourth point was in relation to excessive returns for applicants. Our analysis shows that the subsidy rate in Northern Ireland was very generous. The calculations in our report would show that someone operating a 99 kilowatt boiler, which was the normal boiler that people in Northern Ireland used, for 60 hours a week, would have a profit over 20 years of around £265,000, which is an annual return on investment of about 30% per year. If the boilers run 24 hours a day and for 7 days a week, just all the time, it would increase profits to £738,000 on that boiler, or an annual return of 82% on investment. Also, the fifth point was a lack of checking of claims by the department. And the department had placed a lot of reliance on Ofgem to carry out checks, and it appeared to us sometimes that the control of the scheme had been handed over almost entirely to Ofgem. Because Northern Ireland is a small part of Ofgem's overall business, the actual amount of checking, physical checking carried out by Ofgem is very low, and I think only 0.86% of applications in Northern Ireland resulted in a physical inspection. Also, an interesting point was at the time of our audit work, the department wasn't able to provide a list of companies that were using the scheme, or that were receiving money under the scheme. It didn't have that analysis. Only Ofgem had that analysis at that time. The sixth point again is the impact on the block grant. I mean, Derry's understanding throughout appears to have been that the cost of the scheme will be met through annually managed expenditure direct from Treasury and not from the NI block. However, the department should have realised that this wasn't an unlimited commitment from Treasury, because there were emails in 2011 and 2014 which indicated that the Northern Ireland share of funding will be limited to a Barnett formula share. But they didn't. That wasn't picked up, and the huge spike in demand then shows that we're committed to payments of around 350 million over the next 20 years, and 140 million specifically in the next 5 years. The final point then was in relation to whistleblower claims. There was a whistleblower to OFM-DFM in January 2016, making allegations about the scheme not being properly monitored. Large factories having 3 biomass boilers, running them all year round and collecting £1.5 million over 20 years, and a farmer who had no need for a biomass boiler who's collecting £1 million over the next 20 years heating an empty shed. And I suppose while we have no direct evidence in relation to those specific cases, there's no reason, we have nothing to say that those things certainly couldn't have happened. The scheme would seem to allow that, the rules wouldn't prevent that. In terms of actions being taken by the department has commissioned an independent review of the scheme, which will include site inspections to assess whether its operation is in compliance with the scheme regulations, and if there's any evidence of the scheme being abused or applicants failing to operate within scheme regulations, and they hope to have preliminary results by the 23rd of September. That's all I was going to say at the moment.
Okay. Tomas, thank you. Karen, have you anything to add at this stage? Okay, members, because of the nature of this session and where we're at in the inquiry, we'll now be moving into closed session. So. This is an